Thank you, Mr. Chairman, and thank you to our panelists for joining the committee today. Judge Fogel, the Judicial Conference has issued a code of conduct which applies to the district and circuit courts, correct? And as I understand it, one of the tenets of that code is that judges should avoid any conduct that can lead even to the appearance of a conflict of interest, correct?
That's correct.
And why is that important?
Because if there's an appearance of a conflict of interest or an appearance of impropriety, then the people who are affected by the decisions that judge or judges make rightly lack confidence in it. They suspect that it's not a fair decision, that there are improper influences.
The appearance of a conflict of interest.
That's correct.
Can undermine public confidence in the integrity of the judiciary, correct?
That's correct.
Judge McCasey, putting aside the question of how such a code of conduct might be applied to the Supreme Court, and I recognize and acknowledge that there are separation of powers and constitutional concerns that need to be carefully weighed in considering the design of such a system. Do you agree with Judge Fogel that the appearance of a conflict of interest can reasonably undermine public confidence in the impartiality of a judiciary, whether it's a district or a circuit or the Supreme Court?
Of course, so long as you articulate what it is that appears. People often say the appearance of conflict and feel that that's just kind of a nice vague term that they can use to cover a concern about something else. I think if you allege in particular as to a particular Supreme Court justice that there is an appearance of a conflict or an appearance of impropriety, you have some obligation to articulate what it is that appears.
But you agree, Judge you agree, Judge McCasey, with the principle that as for district and circuit court judges, where they are advised and governed in part by a judicial code of conduct through the Judicial Conference, that they should avoid any appearance of conflict of interest or impropriety because it can reasonably undermine public confidence in the impartiality of a judiciary, that the public could also reasonably, depending upon the facts, lose confidence in the integrity of the Supreme Court depending upon the conduct of justices.
Right, and it has to be reasonable. I recall writing on that subject when I was asked to recuse myself because I am a Jew and a Zionist from judging a case involving some terrorists. I refused, and I wrote rather long and elaborately on that topic.
That's right, but you did not, Judge McCasey, and I asked this rhetorically, and I know the answer is no, you did not as a judge or do not as a judge accept foreign travel in the hundreds of thousands of dollars from politically active parties, correct?
From politically active? No, I did not.
Professor, and I think reasonably you might have been concerned that such conduct would have created some public concern about your impartiality and probably would have avoided that conduct even if it weren't strictly illegal for that reason, correct?
I was never offered that conduct because I don't know people
But that wasn't my question. My question is, as a judge, you quite reasonably and properly would avoid accepting such lavish gifts because of the concern that it could create public doubt in the impartiality of your judgment. Is that right?
The only time that I accepted travel and accommodations was from a seminar in economics that I found enormously valuable that was then obliterated because it was said that that created the appearance of conflict.
And Judge McCasey, I'm not in any way questioning or even seeking to interrogate your personal conduct. What I'm asking you is that as a judge, is it fair to say that you most likely would have declined an offer of foreign travel worth hundreds of thousands of dollars because, quite reasonably, you would have had the concern that public disclosure of such travel could have undermined public confidence in the impartiality of your judgment? Simply
because it amounted to, I mean, if somebody took me, I mean, if I were a district judge and somebody wanted to fly me on his private plane on a vacation with his family and I were friendly with that person, would I have refused and endangered the friendship? I'm not sure that I would have.
Well, I think the American public sees that kind of conduct and quite reasonably asks the question whether it's appropriate. And my impression is that most judges at the district and circuit level, considering the guidance in the Judicial Code of Conduct, Judge Fogel, I don't know if you agree with me, would refrain from such acceptance for that very reason.
Well, I think it's interesting, Senator, the California Code of Conduct, which is very similar to the federal one, there actually is guidance that when you receive social hospitality, you receive a gift like we're talking about here, that you should consider the size of the gift. That's one of the factors you should consider. So that it's one thing if somebody takes you out to dinner, it's another thing if somebody flies you on a private jet to some faraway place. That actually is not in the federal code of conduct. I think it is one of the questions, one of the hard ethical questions here is you can focus on whether one's accepting a gift like that should be disclosed, which is something that's under the Ethics in Government Act. And then there's the question of whether the sheer size of the gift creates an appearance. And I think there are different opinions about that. But I think when you're talking about the appearance of impropriety, you need to look at the entire context. And I agree with Judge McCasey that it's what is a reasonable question about whether the gift or the hospitality or whatever it is so large that it raises issues of undue influence. I think it's a holistic type of inquiry.
Thank you, Judge Fogel.